how to avoid the fourth-headed monster, nursing homes, $15,000 per month. Oh my. Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, am I responsible for my mom or my dad's nursing home bill? That's a very common question, and the answer is, depends. Folks, pull up a chair, get your pen and notebook out, because today I'm going to teach you whether you're responsible legally for your parents' nursing home bill. You may know me as the author of How to Avoid the Four-Headed Monster of Estate Planning and Elder Law on Amazon. Pick up a copy today, because I will teach you how to slay that metaphorical four-headed beast. And today we're talking about the fourth-headed beast, which is the nursing homes. Folks, nursing homes, do you know how much they can cost private pay per month? Well, in this area here in Massachusetts, they can cost private pay $15,000 to maybe even $20,000 per month. And the question is, folks, are you or could you be legally responsible for your parents' nursing home bill? That's a big one. And you would think from a practical standpoint, the answer would be no. Okay. However, I have seen differently in my professional endeavors as an elder law attorney. So folks, this is the big takeaway right here. If you are the caregiver or caretaker for your aging adult parent, or maybe even another family member, could be an aunt, could be an uncle, could be a neighbor, and you are helping them get situated at the nursing home because they're completely incapacitated, like my late dad was, and he ended up in a nursing home later in the fourth quarter of life. If you are in that position someday, folks, and you are that good Samaritan, child, grandchild, niece, nephew, and you're admitting a loved one into a nursing home, listen carefully. Do not sign the admissions agreement personally. And what I mean by that, folks, when you are admitting a loved one into a nursing home, you're going to be very busy. You're going to be probably very tired and fatigued, and as a caregiver and caretaker, and you're maybe relieved that your loved one is going to be in a safe place receiving quality medical care. And then the nice social worker person is going to hand you paperwork, and they're going to say, fill this out and sign for your loved one. It's just standard admissions paperwork, okay? And although under the Nursing Home Reform Act, nursing homes are not supposed to put guarantor or guarantee language in their paperwork, as a matter of practice, they still do. What does that mean? If you pick up the pen and you sign as the guarantor of your loved one, what that means, if your loved one, say for example, applies for Medicaid benefits to help them pay for that $15,000 or more per month nursing home, and for some reason, if they are not eligible, which is pretty common, if it's difficult for them to receive Medicaid benefits to pay for their long-term care cost, or there's a delay in them receiving those Medicaid benefits, and they owe privately for a period of time, say $15,000 per month over 2 or 3 month period, they may have, do the math, they might have a $30,000, $45,000 private pay bill. Well, if they do not have the financial means to pay for that, and Medicaid doesn't pick up that bill, that balance, and then when they pass away, guess what? Nursing homes are private business. They're going to be looking to collect that money from someone. So when their business office looks at that admissions agreement, and if you signed off on it and they had guarantee language in there and you signed off unbeknown as the guarantor, I've seen it before, you may very well receive a collections letter from the nursing home's law firm looking for you to pay privately, because you guaranteed that if the medical bills were not paid, you were the guarantor. So I advise our clients, folks, do not sign those admissions agreement unless your elder law attorney first reviews it for you. And oftentimes language needs to be stricken and revised in those admissions agreement. And the other takeaway from this educational video, folks, is durable power of attorney. Number one of the big 6 disability planning that I talk about quite frequently. I talk about it in the book, How to Slay the Beast with the Big 6 Disability Planning. Comprehensive durable power of attorney with enhanced elder law powers. If you have a durable power of attorney and you are the agent or the attorney in fact for your loved one, sign, not personally, that admissions agreement. Sign as the attorney in fact. So you're signing under your fiduciary duties as the agent and not personally, not individually. But on top of that, you still have to review that admissions agreement carefully to make sure that you are not guaranteeing payment in the event there's an outstanding nursing home medical bill. So be careful, folks. Put the pause on if you're not sure. Do not sign that admissions agreement. Get your loved one admittance into a nursing home for their safety and for their medical care, but make sure you have your elder law attorney review the admissions agreement prior to signing it. Hope you found this educational video helpful. If so, scroll down, post a comment, post a question, click on the subscribe button, folks, because we will continue to keep you educated in how to slay that four-headed beast when it comes to estate planning and elder law. Folks, thanks for joining us here today at elderlawcare.com.